Okay, so this is the Civil Rights chapter, the second lecture. Now we're going to pick up where we left off. And if you listen to the first lecture, you know that the last thing we were looking at was this question of the Supreme Court and this idea that they had just, the Congress was trying to pass the Civil Rights Act of 1875. Congress, particularly the radical Republicans in Congress, were trying to provide some protection to former slaves and African Americans. That Civil Rights Act of 1875 was actually overturned by the Supreme Court in the civil rights cases, which of course said that states and governments couldn't discriminate against minorities, actual private individuals could. So, if you jump ahead to the next significant case of the late 1800s, that's the case of Plessy v. Ferguson in 1896. And this is one of the most important cases to come out of that post-Reconstruction era related to race, because this is when the Supreme Court actually upheld the idea of segregation based on race. The Supreme Court actually said we could have separate establishments in schools, housing, buses, anything you could think of. As long as they were equal, you can have them separate. And of course, what is considered equal is something that varies. Of course, on your screen, you see Homer Plessy, which, if anyone knows anything about pictures of that 1800s eras, Plessy looks to be white. He looks Caucasian, but in fact, he was 1/8 black, meaning one of his great-grandparents was African American, but he was 7/8 white. And this case actually involved Homer Plessy, trying to get on a segregated train car, and he didn't want to sit in the train car reserved for colored people. He wanted to sit in the white train car, and there were considerable differences. The white train car had velvet cushions, carpet on the floor, there was running electricity, there was food and beverage service. The colored train car had rickety benches, holes in the ground so that you could see the track and the ground as the train was going over it. There was no electricity. Blacks had to bring their own lunch and bring their own food, which they had to buy at each separate stop. And so there was a considerable difference in level of quality of travel. But what the Supreme Court said was, in fact, the point of a train car isn't about the accommodations or the amenities. As long as the nice train car for the whites and the poorly furnished train car for the blacks, as long as they both got you to the same destination, they both ended up in Detroit, Tennessee, wherever that train was going, then in fact they were equal in the eyes of the law. We should say the Plessy decision, along with the Dred Scott v. Sanford decision pre-Civil War, which, look at your U.S. history books, which said that slaves in fact weren't people and free slaves weren't even citizens. These two cases are considered two of the most irresponsible, worst decisions to ever come out of the Supreme Court. So although the Supreme Court gets it right frequently they get it wrong. But I want to jump ahead about 50 years to kind of look at the modern civil rights struggle as we would know it, as we would call it that. So, if you fast forward after Plessy, and Plessy, of course, gave way to the idea of the Jim Crow South, the segregated South, southern states and northern states, midwestern states, even some western states to a certain degree, felt free to discriminate against people because of this Plessy decision. Well, after that, the idea of racial equality kind of took a back burner to several issues. World War I, World War II, Great Depression. But continuing during all those time periods, you had the NAACP, the National Association for the Advancement of Colored People, formed in 1907, 1906, one of those two. You know I don't do dates very well. one of the things the NAACP did was try to grow in terms of numbers, in terms of members. They established the Legal Defense Fund, which was the chief mechanism for trying to fight segregation in the government through the courts. They were the ones who led the court cases to try to end this idea of segregation, to reverse Plessy. And they did that through trying to challenge the structure of segregated schools, segregated housing, segregated employment. So the NAACP is the main African American interest group in a legal sense. Other groups did exist, but this was the main one. And you should thank me, you should be kind to me, you should write me notes of praise and send me flowers. There's about 10 court cases between Plessy in 1896 and Brown in 1954 that I'm not making you know. So you're welcome for that. So we're going to jump ahead to the Brown v. Board of Education decision. And of course, this is the most famous decision that actually ended the idea of segregation. In 1954, the Supreme Court, in fact, said separate but equal is impossible. That segregation has no place under the law. And of course, they relied on that 14th Amendment Equal Protection Clause that we talked about. They said you cannot have an equal system if you're going to have a separate system. Just the idea of inequality creates just the idea of segregation creates inequality, if I could get that out without muddling it too much. And this was one of those rare decisions because this was a heavily divided court, liberals, conservative, moderates, and Chief Justice Earl Warren, who's a Republican appointee by Eisenhower, former governor of California, actually managed to get a 9-0 unanimous decision striking down this Brown v. Board of Education case. One of the reactions to Brown was that Southern legislators, Southern politicians, Southern public servants dug in their heels and they said, you know what? The Supreme Court has no enforcement power, so we don't have to follow this ruling. And in fact, Southern politicians created something called the Southern Manifesto, and they published it in 1956 as a direct reaction to Brown. And it was signed by most of the Southern House and Senate members, and they said, we are committed to the idea of segregation and states' rights. Well, following the assassination of John F. Kennedy, one of the policies that LBJ, Lyndon Johnson, was able to push through Congress was the Civil Rights Act of 1964. This was something first proposed and introduced by Kennedy, but it took the weight and full force of Johnson being president to actually push it into law. Now, the Civil Rights Act of 1964 actually worked to end segregation. It outlawed segregation in public places, said you could not discriminate in employment, education. It created the Equal Employment Opportunity Commission, and it said it's the federal government's role to actually ensure that there is no discrimination. And there are, of course, several layers of legislation that came out of that, but this is the big one. And what we have to understand is this act is purely pointed at what's called de jure segregation. De jure segregation is segregation by law. You cannot discriminate, you cannot have a segregated school system by law. But de facto discrimination, that is, it's not a law, it's just the way it came out to be, is still perfectly okay. So if I have a school that's 95% white, and that's only because the school district is 95% white, that's fine. There's no law against that. And another piece of legislation that came out of this was the Voting Rights Act of 1965. The Voting Rights Act of 1965, which we've talked about several times in class already or in previous lectures, if you're listening to the online lecture series, this is the legislation that says you cannot discriminate in voting practices. You cannot have intimidation, you cannot have literacy tests, you cannot have different standards for registration, you cannot split up a minority neighborhood, what we called cracking. You have to give minorities a chance to vote for someone of their preference. And so this is a big one. When it comes to politics and political engagement, the Voting Rights Act in 1965 is important politically as far as getting blacks and minorities involved. The Civil Rights Act of 1964 was there for employment, school, discrimination. So understand the differences between those two, both key pieces of legislation. Another thing to come out of this civil rights era was the 24th Amendment, which bans the poll tax, which means you cannot be charged any kind of tax if you attempt to register to vote. You cannot be charged any kind of tax to actually show up to vote. Voting is supposed to be free and fair. And the interesting thing about the 24th Amendment is that this is probably one of the last major amendments related to the actual act of elections. Um, Switching gears, we also need to look at the issue of gender inequality. How does the idea of sex and gender discrimination play out in a civil rights manner? Historically, the United States has had a traditional view of what we call protectionism. When we've looked at women, we as a society have said women are special, women are fragile, they need to be spared from the cruelties of life. And so, male-dominated legislatures, governors, governments would make laws that viewed women that way. Either women were just too inferior or too frail, too fragile, too special to participate in some of the seedier parts of life, i.e. governing. Justice Brady actually quoted it best by saying, "Man is or should be woman's protector and defender. The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life." So, sorry ladies, according to Justice Bradley, you're just too fragile. But we know that, much like African Americans, over time we've had legislation and constitutional amendments aimed at chipping this away so that now we're in this time of greater equality and greater access between the sexes than ever before. Some key examples: in 1920, we passed the 19th Amendment, which language was very similar to the 15th Amendment. If you look at the 15th Amendment and the 19th Amendment side by side, they're virtually identical, except the 19th Amendment says the right to vote shall not be discriminated against on the basis of sex. So that's the big difference. In 1963, Kennedy signs the Equal Pay Act. In 1972, Congress voted for that Equal Rights Amendment, which we've talked about, one of those amendments that got proposed but never ratified. It failed to get the necessary 38 states. It got 35. But then 1972 did give us Title IX, which is especially important in a college setting. Those of you who enjoy college, maybe you're enjoying your experience, you know that we're supposed to be equal on the basis of gender. We cannot discriminate in funding for sports. We cannot discriminate in types of amenities offered. Things are supposed to be equal in education. And if you look and if you notice, in fact, now on college campuses, women outnumber men. So we do see the tides are shifting. More women are in college than men. And the women's rights movement itself is interesting because there are all these different sociological layers that are associated with it, different interest groups associated with it. And these are things that we're going to pick up on and touch upon in the third lecture. And then in the third lecture, we're also going to look into some other areas of civil rights and some other affected movements. So we're going to stop here because I think I'm going to go get a slice of pizza, a little bit hungry, come back, and we're going to look at that third lecture, which finishes up our discussion on civil rights. So this concludes Lecture 2, and make sure you check in for Lecture 3, finishing out the Civil Rights series.